Alex here with part 224 of the My Docket series on child custody and visitation. As my previous videos, I'll take this opportunity to direct my viewers to part 0. If you haven't seen it yet, that's the video that contains a detailed disclaimer and the underlying purpose of the series. Two things that I will glaze over are, number one, I'm not in the middle of this right now. My case is completely and totally over. It's closed. It cannot be reopened, and that's because my ex's parental rights have been terminated. Number two, the nutshell version as to the purpose of the series, to give my viewers one big example of my 8-year-long high-conflict child custody ordeal from beginning to end in chronological order. We go into the Supreme Court's order denying petition for writ of mandamus. They declined the petition, which means that they didn't state that they denied it because the judge was correct. They state that they declined to even consider it because they have the power to do that with writ petitions. If you haven't seen the video writ petitions, please watch it. I explain how that works. Writ petitions are frequently declined. I think more than somewhere between 50 and 60% of them, they don't even bother to review. They are within their rights to do that. The reason goes to the legislature's enactment of a series of statutes on how writs are supposed to work, which is very different from these other statutes that discuss appeals. If you haven't seen my video filing an appeal, definitely take a look at that, because as I explained in that video, the Supreme Court is mandated to review every single appeal that is filed, as long as they have jurisdiction, which that is its own ordeal. If you want to learn more about that, definitely watch the video on the topic filing an appeal. So in this case, if you remember correctly, the appeal was dismissed for lack of jurisdiction for the reasons that I explained in the video. Special order after judgment. Yeah, that's the correct video. For the reasons in that video, they said they didn't have jurisdiction to consider it under an appeal. I did not immediately file a petition for writ of mandamus. I had already suspected that they were not going to entertain a writ petition. It took a few months, I think it was 2, 3, maybe 4 months later, that I noticed another person filed an appeal on the same issue, only in his case, the judge told him he needed to go through the ordinary process like I was. And in my case, of course, my judge was saying that I needed to file a writ of execution. And in both situations, two different judges were saying two different things. So once I saw that other appeal, I thought maybe this will convince them to consider a petition for writ of mandamus. That's why I filed it. And in the end, they didn't consider it. So hindsight, obviously, if I would have known they weren't going to consider it, I wouldn't have filed it. The other thing that I want to mention is part of the reason that they decline writ petitions is because they may feel that a particular issue will resolve itself on its own anyway later on. And the Supreme Court ended up being right, because even though they declined this petition, I ended up getting the money anyway when it was seized from my ex by the district attorney's office. I don't remember, maybe 1 or 2 years later, they ended up getting, there was one seizure and then one voluntary pay. So in the end, I still ended up getting this money, and I still ended up closing all of the cases out. The last thing that I was going to say is my mindset. It was very frustrated. I was very annoyed. At the time, I thought it made no sense because I won the appeal over $50, but they didn't want to consider a writ petition over $500. But then I didn't know what I know now, which is that they have to consider appeals whether they like it or not. And so even though it was only $50 and they probably would have thought it wasn't worth their time, they just couldn't get around it because appeals must be considered. So that's why they considered the $50 appeal, and they did rule in my favor and overturn it. Writ petitions, they have an option, and that's why they chose in this case, nah, we're not going to consider it. And that was the end of that. All that being said, this is a huge learning opportunity for people because I went through a lot of logical reasons as to why I filed it, and it still wasn't considered. And that's something that my viewers can sort of, I guess, learn from. I'm going to go ahead now, and we can go and take a look at what the Court of Appeals has filed. Here we have the order denying petition for writ of mandamus. Standard introductory paragraph, they're indicating it's an original petition for writ of mandamus challenging a district court order denying my motion for a third-party debtor exam and other relief. A writ of mandamus is available to compel the performance of an act that the law requires from the government. A writ of mandamus will not issue if the petition has a plain, speedy, and adequate remedy at law. This doesn't apply because I didn't have an adequate remedy, so this doesn't block me. But next sentence does. Further, mandamus is an extraordinary remedy, and it is within the discretion of this court to determine if a petition will be considered. The petitioner bears the burden of demonstrating that extraordinary relief is warranted, and having considered the documents before us, we conclude that I have failed to demonstrate that extraordinary relief is warranted. Accordingly, they deny the petition. So you can see here, they didn't go into any of the actual details of the case. They didn't discuss the unclaimed property division. They didn't discuss the Secretary of Treasury's request for a letter or an order from the judge. They didn't address any of the statutes, any of the laws. They just decided that it's within their discretion to not consider it, and I haven't shown why they should consider it. So that's very different from me being wrong. There's you being right, you being wrong, and then there is we just aren't going to consider this one. And that's the third option that they chose. That's what they, as I mentioned earlier, that's what they frequently do with writ petitions, and that's what they did in this case. Here we have the notice in lieu of remittitur. This is similar to a remittitur, which only issues in appeals, and since this is not an appeal, they have to have some way of communicating to the lower court that they're done with an issue, and so this is how they do it in Nevada. They'll issue a notice in lieu of remittitur, letting the lower court know that they're done with this issue, and that's really all it does. It doesn't affect jurisdiction in any way. With an appeal, jurisdiction is affected. If you want to learn why, you can watch the video on the topic, Jurisdiction Divested on Appeal. Going into the aftermath, I filed nothing, so I incurred $0 in costs. My ex didn't participate, so she incurred $0 in costs. I didn't have an attorney, so I incurred $0 in attorney fees, and my ex didn't have an attorney either, so she incurred $0 in attorney fees as well. As my previous videos, if you have any questions, feel free to post them down in the comments below, and I will see you guys next time.